This is Las Vegas Real Estate Now, where we bring you the 3 E's: educate, empower, and engage. I'm your host, Harvey Blankfeld, along with our co-host, Shelley Brown, and we've been selling homes here in Southern Nevada since 1988. Shelley and I are also very proud to be part of the Real Estate Radio Network. That is a national network of local real estate professionals delivering timely, balanced truths about local market conditions. But we also have Jon Morgan. And Jon, I wanted to talk to you a little bit today about some recent changes we had with regard to HOA foreclosures. Tell me what's happening with this. There's a 60-day right of redemption. Tell me how that works.
There is. Well, just to back up, maybe for your listeners who haven't heard me talk on this about this subject before, Nevada has gone through over the last 3 or 4 years a frenzy of HOA foreclosures, and that has resulted in banks having their first mortgages wiped out, extinguished, and has invariably led to many, many court battles. There was, in September of last year, the Nevada Supreme Court finally heard a case that directly addressed this question of whether or not foreclosure of an HOA lien, non-judicial foreclosure, auction-style foreclosure, does in fact extinguish a bank's first position deed of trust. And the court ruled that yes, that's what our statutes say. You know, as part of the attempt lobbied by the Mortgage Banking Association in the last legislative session in Carson City, what ultimately came out of that session was SB 306. And SB 306 was passed at the end of May of this year, but starting October 1st, there's a dramatic change in the way that HOA foreclosures have to be conducted, and the rights of lenders and former owners to redeem the property for the first time after that sale occurs.
Right. So they have 60 days beyond that now to redeem it.
Correct.
Okay.
That will be the new rule.
Yes. I think it's a nice step in the right direction, but let's say all these people, let's say I bought 30 houses, HOA foreclosures, and I want to sell them now, Jon. Am I going to be able to sell them through a title company?
By and large, the answer is going to be no. Still, and now keep in mind we haven't seen how this is this new SB 306 is going to affect the decisions that are made in the title insurance industry. But as it stands right now, it's certainly until October 1st and a little thereafter, when we have time to see how this actually plays out. The title insurance industry is generally unwilling to insure a title that's acquired through an HOA foreclosure.
There was also some federal court decisions regarding GSE, the government service entities. What happened? How does that impact it?
Well, it really muddies the waters as far as whether or not Nevada's HOA lien priority statute, which does grant and now has been upheld by the Supreme Court, grant the HOA's portion of their lien is given super priority. There have been 2 key decisions that have come up here just recently. In June 24th, there was a ruling said that the HOA's foreclosure of a property in which the government service entity, so Fannie Mae or Freddie Mac, was the record holder of the beneficial interest of that loan, that federal law preempted a state law from extinguishing a federally insured mortgage. A subsequent, more recent decision just came down on July 27th, confirmed or expanded that beyond to say that an HOA foreclosure sale did not divest Fannie Mae's deed of trust on the property. So right now we've got a handful of key court decisions that appears to paint a picture that is leading to a conclusion that the vast majority of our residential mortgage loans, which are insured by Fannie or Freddie,
that's a lot of loans.
Somewhere in the neighborhood of 70%, are going to now be ineligible to have to be extinguished.
Right.
You've been listening to Las Vegas Real Estate Now with hosts Harvey Blankfeld and Shelley Brown. Please tune in every Saturday at 11 a.m. right here on News Talk 720 KDWN.